Good evening and welcome back to the lecture series of CLAT Competitive Examination Preparation for 2023. And in this particular lecture series, we were talking about one important aspect of CLAT syllabus, that is legal reasoning. And in that particularly, in legal reasoning, we were talking about the criminal law that has been a part of the syllabus of legal reasoning. So basically, the legal reasoning subject as such has been divided into six major categories, and in this particular lecture series we are going to tackle each and every subject in a detailed manner, and we'll try to understand that what exactly are the things that one CLAT aspirant is supposed to study, and how he can assure that by completing these topics and by persistent practice and being consistent for during your preparation, how you can excel in this particular CLAT examination. In our previous video, we have discussed about what exactly are the different things, or maybe the principles that is required when we talk about criminal law, and what are the things one has to ensure if at all there has been any sort of criminal activity uh, in the society, and how that the offender or the criminal who has been accused of any crime should be punished. So we have understood a lot of things in our previous lecture. In this particular lecture, I would like to just revise you, help you in revision of the same. In that particularly, in the first lecture, we have talked about what exactly is what exactly is crime, and when we talk about this, we have talked about what exactly is crime. It is an unlawful act that is punishable by a state. We have taken the description example of a person who was drowning in water, and there was a person who was standing, a bystander nearby, but he didn't help it. So whether he will be held liable for any of, whether he will be considered as a offender or not, that is something that we talked in our previous lecture. We have also talked about the common law principles of the criminal law is that unless until an activity is prohibited by law, it does not qualify as a crime. So that example, I suppose you people were able to recall that that particular example was actually talking about the maxim that we have studied, and that maxim was actus non asset reum nisi mansit rea. In that particular maxim, we talked that an act does not become a guilty act until and unless it is accompanied by a guilty mind. So we have talked about the different stages of crime. We have talked about intention. We have talked about preparation. We have talked about um, motives. We have talked about the commission of the crime. This particularly intention, preparation. We have talked about intention, we have talked about attempt, we have talked about preparation, we have talked about the commission, and we have also talked about the exceptions for the same. During a CLAT examination, what you need to remember and recall every time whenever you're preparing is that these sections, or maybe these stages which I'm talking about as of now, intention, preparation, attempt, and what exactly is the exception of the same, because you won't be finding out questions seeing the difficulty level of the CLAT examination that is growing by year, that the questions are not being asked from the general concepts, but rather what are the exceptions of the same. And that it becomes perhaps important to understand that whenever there is an underlining exception, the candidate, the CLAT aspirant, is supposed to understand that exception in a very clear and in very clear manner, so that they can cope up with the questions that will be present in front of them during the CLAT examination. What happens is that the student understands the general concepts, but eventually there are certain exceptions that are attracted to it. Let's take the example of the stages of crime itself. I told you, and it has been already mentioned also, that intention and preparation does not give any rise to the liability. Means a person cannot be punished for just intention and preparation. But yesterday I told you that there is an exception that is attached to it, and that exception perhaps talks about decathy. Decathy is also an offense. It is a criminal offense, and then the criminal offense, even intention to do decathy is punishable. Now, how you're going to prove that there was intention or not, that is something that you need not bother about as of now. Because what you need to understand is that the questions that will be there in front of you, our main goal, our main agenda is to solve those questions to get the correct answers. So the principles will obviously be mentioned there in your passage itself. All you need to remember is that what exactly is the underlying exception. Because what will happen is that there will be a question where which it will be mentioned that there are stages of crime. There are the four stages of crime. One is intention, preparation, attempt, and commission. And then there will be a factual question that will be put in front of you, where which there will be a narration of a decathy that is taking place. And then in the end of that, and in the end of that passage, there will be a question where which you will be asked that the catty has happened, and whether, but the catty was not able to take place because there was no attempt as such. So whether any of the accused can be held liable. The answer to the general concept and based on the principles that will be mentioned there would be no, they will not be punished, but the answer will be wrong, because there is an underlying exception which I just told you, where which decathy can be the person can be held liable for decathy if even if he has the intention and we are able to prove the intentions. How to prove and what to prove, again I'm telling you, it is not your cup of tea. You are not supposed to study it, because once you are in law colleges you will only be understanding how this particular particularly applications of the evidences and everything takes into account, but rather you are not supposed to study those things, so we will not be indulging ourselves in that particular direction. So after understanding that what exactly the intention, preparation, attempt, and commissions are, and understanding the principles underlining it, and the candidate also has to make sure that they are understanding the exceptions, because exceptions will help you to find out those areas where which you will be standing apart from the crowd that are going to give the examination, because 99% of the candidates will obviously be studying about what exactly is the intention, what exactly is preparation, attempt, and commission, and what are the crimes, what are the punishments that can be given for it. But there are often, it has been seen that the candidates are not very much clear about the exceptions, and there that is the perhaps the reason they are not able to cope up and they're not able to get excellent marks in this particular subject. But when you talk about legal reasoning, if you see that there are 35 to 40 marks that will be allotted to this subject, you can guarantee that you are scoring 100 out of 100 if you are following the path which I'm going to tell you, and obviously you are focusing over the principles and you are practicing consistently. Because as I've told you again and again, that the consistency is the main key if you are going to excel, if you are planning to excel in this examination. Just mere preparation, just trying to mug up things is not going to help you out in clearing this examination, but rather how you are preparing and what exactly is your method of understanding becomes a very crucial aspect while preparing for CLAT examination, specifically for legal reasoning as such. Because if you talk about the rest of the subject, if you talk about English, if you talk about logical reasoning, so logical reasoning is all about practicing. What you need to do is you need to consistently practice and practice and practice, and obviously after practicing you will get acquainted to the problems, and then the problems will evolve in that particular way only. And once you're acquainted with the problem, you know that after this particular if you talk about a series 1 3 5 7, then what will be the next number after that? You know that if the series shows that it is about the odd numbers, and the next number will be 9. So but when you talk about legal reasoning, there are plethora of principles that is working behind it, because we have a lot of legislation that is there, and the syllabus of legal reasoning as such is also very wide. So we have to only focus over those areas which are very important for us, and that if we have understood it and we have applied it in the unseen in the passages that we will be getting, and in those passages we are able to mark the answers correctly, then you are good to go, and you will be obviously I'm 100% sure, I'm confident that you will be you will be passing with flying colors in your CLAT examination. At least you will be confident that you will be able to score 100 out of 100 in your legal reason. Okay, so with that, I would like to continue with today's lecture. We have completed all these points that were there in the yesterday's class. Now we have studied what is mens rea, we have studied about what is actus reus, we have studied motive, we have studied intention, and we were about to study what are the major objectives, what are the sources, what is Indian Penal Code. So basically, if we talk about sources, we have already dealt with that. These are the sources of your criminal law. We are talking about the special local laws. We are talking about some laws that have been applicable in the local areas. It might not be applicable in different other state. Okay, for example, a local law that is applicable in Rajasthan, it might not be applicable in Uttar Pradesh. But when we talk about legislations and such, when we talk about the rules that is going to be applied on the whole of India, then the important three legislations that we are talking here is obviously the Indian Evidence Act, the Code of Criminal Procedure, and the Indian Penal Code. In today's lecture, we are going to talk about the major aspects of Indian Penal Code. And in this particular subject, what we are going to understand is three major points. First is, what are the important sections? Why I'm talking about sections, I'm not why in the earlier lectures I've talked about that I won't be going into the sections, but now I'm talking, so it might be a confusing or conflicting aspect for you, but I would like to clear things to you so that you can understand that when you're talking about sections, what we are talking about is we are talking about the offenses, and in these definition of the offenses is the underlining principle. And what you will get in your paper is actually IPC offenses which have underlining principles. Underlining principles put in the form of passages. And based on those passages, there will be questions. And the source of these IPC offenses is obviously the sections. And those sections has been mentioned under the IPC Act of 1860. Therefore, it becomes mandatory and necessary for the candidates who are preparing for CLAT examination that they are acquainted with not almost all the sections of IPC, but the major sections, or if I'll say the major offenses. If we talk about some major offenses here, then we're talking about murder, or rather, if I'll categorize this, so it is offenses against the body. Against the body, this is first. Let's remove this one. Then we are talking about offenses against the property. Then third, we are talking about offenses against peace and tranquility. So when we talk about peace and tranquility, what we are talking about is that this is body, it is the human body. When we're talking about body, we're not talking about animals, rather what we are talking about is the human body. So there is a one particular chapter. I would like to just first inform you about IPC first. The IPC consists of 23 chapters, which is divided into subdivided into 511 sections as such. So there will be one chapter that will contain a bunch of sections, then there will be another chapter that will be containing another batch of sections, and this is the way forward. So in those particular chapters, there is one chapter that is dedicated to dedicated to the offenses against the body. There is one chapter that is dedicated to offenses against property, and then there is one chapter that is dedicated to offenses against peace and tranquility. And so these are the three important portions that you need to study. But the most important portion that one has to be acquainted with, and which you can expect majority of the questions to be, is the general exceptions. Okay. Now you must be confused. It's okay. Now there are 23 chapters in IPC. We have to study offenses against body, offenses against property, and offenses against tranquility. Now, what about these general exceptions? Are these general exceptions present within this chapter, or it is dedicated to another chapter? So I would like to tell you, under IPC Act of 1860, there is a dedicated chapter over the general exceptions, and if we read it along with the section 6 of the Indian Penal Code, I'll just like to show it to you so that it will be easier for you to understand. Okay, before that, we'll just, if we go forward with that, let me just quickly tell you. I suppose general exceptions. Till this point, I suppose the things are clear to you, that what are the things that we need to study and why is it important for us to study the IPC Act 1860s as such. But before moving forward and before showing you the legislation, what exactly IPC Act 1860 looks like, I would just like to clear some points to you so that it becomes easier for you. Yes, if you can see the screen, let's summarize and let's try to understand what IPC 1860 is all about. So IPC 1860, as I've just told you, that it is divided into 23 sections, comprised of over 100 over 500 sections, 511 to be precise. And the code starts with the introduction, provides explanation and exceptions used in it, and it's a wide range of offenses. So when we talk about exceptions, becomes a very important portion for any of the CLAT aspirants to understand, because based on those exceptions there will be a question. For example, I'll give you an example for your better understanding. X has murdered Y. Now X has murdered Y, this is a fact. But X was under influence of alcohol administered to him by Z. So now X never used to drink the alcohol, but after being intoxicated because of Z, Y murdered, X murdered Y. So now, if you can see the first fact, if you see the first instance, it shows that X has murdered Y, though therefore obviously X should be held responsible. But there is a general exception that has been mentioned under section 76 of your Indian Penal Code. The section which starts with general exception just starts with section 76 of the Indian Penal Code and goes till section 105 of the Indian Penal Code, and perhaps that is the most important area that a candidate needs to understand. The general concept is that if X has murdered Y, then X will be held liable and will be punished for murder, right? But then there is an underlining exception also, which says that if somebody is being intoxicated involuntarily, okay, involuntarily, meaning which that they by themselves never chose to drink, but it was administered to them by some another person without their will. And after consumption, they lost their mind and obviously they were not able to judge what is right and wrong. And in that particular scenario, X has murdered Y. So the Indian Penal Code suggests that if this type of action has been done, so if obviously the person who is X will not be held liable, because the action that was done by him obviously does not contains one important aspect that we have already studied in our previous lecture, and that is mens rea, which known as guilty mind. Now again, Z, if you talk about Z, whether Z can be held responsible for the murder of Y, the answer will be yes. He might not be held for direct murder, but he can be held under the section of abatement to murder. Okay, and perhaps the punishment is the same for both the. So now you see the beauty of this particular legislation, that if somebody has not done anything without the intention, if they have done anything without the intention, then they shall not be punished. but it will be falling under a general exception. So that is why it becomes very important for the candidates to focus whenever we are studying IPC, to focus our mind over these exceptions. Once you are acquainted with these exceptions, and whenever there is a problem, it will be a cakewalk for you to cope up with those questions, and you will be able to solve those questions very easily. So I suppose that you have understood that what are the important underlining features that one has to go through and why we have to go through. So, and now we will be moving forward with this to our another. Yes, I suppose the screen is visible to you guys. So this is what your Indian Penal Code actually looks like. So I suppose you have this is your Indian Penal Code. This is what Indian Penal Code looks like actually. Indian Penal Codes. If you can see the screen, this particularly, this is the PDF format. It is of 112 page, and in this particular legislation, and this obviously is a government document. In this, you will find mentions of different chapters that has been mentioned there. If you can see the screen, there's chapter 1, which talks about introduction. So the introduction of the Indian Penal Code. Introduction of the Indian Penal Code. So if you talk about the chapter 1, it talks about the introduction. The first and the foremost thing that you will find here is the mention of preamble. Preamble means that what is the object of this legislation, or if I will say the act. If I'll just scroll it down for you so that you can understand what is the preamble saying. And obviously we will go through each and everything which is important for you. I will be helping you in marking those things down which is important, and one has to keenly and observe and understand these particular topics, because the questions will be coming from these areas only. So if I just show you, I just showed you the index format. Now the Indian Penal Code, if you talk about the legislation, starts from here. It is the 45th act that was created in the year 1860. When you talk about act number 45, what does that signify? It signifies that it was the 45th act that was established in the year of 1860. See, it was mentioned and it was enacted on 6th of October 1860. But this is something that you need not study, you need not retain, you need not understand it, and you not focus your mind over it. This is just to make you people understand that what exactly is Indian Penal Code and why is it important. Why is it important, guys? Because Indian Penal Code has is the source of all the sections which are defining the crimes that can be punished under the territories of India. And once we are acquainted with what exactly is the definition of crime, what exactly are the requisites that is essential to make sure that this particular crime is committed, we need to understand that how and where we need to study. So this particular legislation is the exact source which a candidate should be referring to, not any online site, not any reference book or anything of that sort, but rather the principles as such. So you are expected to understand that these are the underlying principles, and that can only be done if you are acquainted with this particular legislation. So as I've just informed you that we were talking about the preamble, and when we talk about preamble, it is said, I just informed you that it is going to explain you the object, where it is expedient to provide a general penal code for it is enacted as follows. So it is what it is saying, that it is providing a general penal code. It is the code that will be applied generally throughout India. And what are the offenses that can be considered as an offense for which punishment can be given is mentioned in this particular act. So you need to understand this act. I'm not saying that you're going to study the whole 511 section that has been mentioned as such in your act, but there are certain sections that becomes very important. And before starting off those section only, I would like to teach you, and obviously I will like to recommend you that you should also be going through the general exceptions. But before starting that, I would like to acquaint you with the act as such, because once you have understood the act, when you have gone through the index, or maybe if I will say the content that is there, it will becomes very easy for you to understand the Indian Penal Code as such. Okay. So if you can see the screen, it starts with the chapter 1, and if we scroll it down, so that how to what extent the chapters are going, chapter 10 is there, chapter 11 is there, chapter 12 is there, chapter 13, 14, 15, 16, 17. So I just informed you that you are supposed to study uh, offense affecting the human body, yes or no? Yes. If you recall, uh, the previous minutes of this lecture, we were talking about offenses against the human body. This is a very important portion. So you just have to mark these things down, that which chapter is becoming important for you. So if you talk about, so chapter 16 becomes an important portion that one has to study. See, now there are important sections. And again, you are not supposed to study each and every section that has been mentioned as such. Okay, you are not supposed to study that what exactly is culpable homicide, what is murder, because I will try to explain you each and everything in a very simple, crisp and clear manner, so that you at least have an idea that what exactly is this section all about. And when we will be studying these sections, what we have to understand is that after each and every section, when we will be studying culpable homicide, okay, so the sections appears like this, that there will be the mention of the section 299, then this will be culpable homicide, and then the definition of culpable homicide will be there. After the definition, you will find some illustrations for your better understanding. And that is why whenever I'm teaching, I provide you illustrations for your better understanding. In the same way, the Act has also provided you with different illustrations, so that it becomes crystal clear that what exactly is culpable homicide, how is it different from murder, what exactly is abatement to suicide, what is attempt to murder, how will a person be considered to be an offender under section 307 and not 302, where which it is talking about attempt to murder and murder. So there are different things that one has to go through and acquaint with. So that is what will be trying to understand in our current lecture. Moving forward, so I've just informed you that this is the chapter that is one of the most important areas from where which you will can expect the questions to be. And then after that, you have chapter number 17. So chapter number 17 also becomes an important portion for you guys, because there will be questions on these topics, specifically theft. What is the punishment of theft? Though you won't be granting questions from these type of questions, then obviously you need to understand what is extortion. You're not supposed to go into depth and understand this particular topic. You are supposed to study what is robbery, supposed to study decathy. You're not supposed to study all these things. Again, I'm telling you. Then you have to study, these are two important portions. What is dishonest misappropriation of property? What is criminal breach of trust? Then obviously you don't have to get indulged in these different sections that has been mentioned. So if then you have to study what is cheating, important portion that we have to go through. And what is this, perhaps is also not very important, but we'll have a superficial idea of the same. Then what exactly is mischief? Mischief questions are very, majority of the time the questions are asked from this portion. So it becomes a rather important yet easy topic to study. Once you are able to complete that, you will be able to get a good amount of correct answers. Then this becomes an important topic also, what is criminal trespass and what is house trespass. Rest, obviously you need not study. And this chapter also, you're not supposed to study chapter relating to documents and property marks, because this is something that you will be getting in your exams. And after that, after studying that, you have to study chapter 21 also. It's a very important chapter of defamation. You will get questions from there also. And 498A of cruelty by husband or relatives, that is sometimes being asked what exactly is cruelty according to section 498A. Then you are supposed to talk about criminal intimidation. This and this are important portions. This also. are important portions from which you can expect questions to be there in your Indian Penal Code. So obviously, before starting these areas, and obviously this chapter, offenses against to the human body, is perhaps important in every aspect, but we'll see that what are the things that we can neglect. Then this chapter is not supposed to be studied. Same goes with the other chapter also. You're not supposed to study. No, we can study. You have to study this particular portion, public nuisance, because it is related to public health, safety, convenience, and this. So public nuisance becomes an important portion, and adulteration of food and drugs with the intent to sell or becomes an important portion. And what are the exceptions to it underlining these principles? One has to go through it also. You're not supposed to study weights and measures. You're not supposed to study this particular portion also. Neither you're supposed to study chapter against public justice. Not supposed to study legal authority. You're not supposed to study elections. Neither you're supposed to study all these points. So it becomes totally irrelevant for me to teach you all these things because they are of no use for you. But the most you have to study criminal conspiracy becomes an important portion, chapter number 5A. You should know what is the definition of criminal conspiracy and what exactly is sedition, because sedition has been in news in current days. So there are expectations that you might get questions which is in relations to sedition also. So what we need to be acquainted with is that the important sections that are there, because from those important sections we will be able to find out the underlying principles, and after just seeing to it that if there is an underlying principle that is being utilized in your problem, and there is no exception that is being mentioned in the fact that is being given in the passage, you can apply those general principles and you can find your correct answers. But even if there is an exception that has been attracted to it, then it becomes a very easier task, because once you are acquainted with the general exceptions, you will get to know that if this particular general exception is present, then the person will not be held liable for the act that he has done, and rather he shall not be punished for that crime. So that is why we need to we need to get acquainted with these sections. We need to study those sections in a detailed manner, and after studying those sections, we are talking about general exceptions here. After understanding those sections, we are expect that you are able to approach the questions that will be there in your CLAT examinations in a very crisp, clear, and precise manner, and that will ensure that you are able to cope up, you are able to solve those questions, and you are able to get the right answer marked. So let's move forward and let's try to understand what are the things that we need to study. This chapter number 4, it is, whatever, if I would say it, then it is the main source of your questions, because there will be a question which, let's take an example that might be related to 302, that is murder, and there will be an underlying exception that will be attached to it. Okay, the general exceptions, there will be an underlying exception that will be attached, and then there will be a question that whether X, Y, Z or anybody else should be held liable for punishment, held liable for murder or not. So once we have acquainted with the exceptions, it becomes very easier for us to solve those questions and to get the correct answer. So with this, I would like to start with chapter number 5, chapter number 4, I suppose, which is going to talk about the general exceptions, because once you are acquainted with the general exceptions, as I just informed you, it becomes very easier for you to cope up and get the correct answer. This is Indian Penal Code. This is chapter number 1. It goes to chapter number 23. We have studied about preamble, title, extent, and something. These are the things that you need to know. General explanations. General explanations provide us the definitions of the different terminologies. And I've just informed you while we were studying the definition of this in this code can be understood subject to exceptions. So what it is saying, that whenever there is a definition of any offense, it has to be understood by taking into consideration the exceptions that has been mentioned under chapter 4 of this IPC. So once the candidate is acquainted, with these exceptions and the definition of the offense, applying these two over a fact that will be given in a form of question, the candidate is expected to get the right answer. So you see, although it might look a little bit complicated to you, but I have just tried to summarize the importance of this whole class in this particular page, which the most important portion, the most important thing that one has to study is obviously the general explanations, or sorry, not the general explanations, I'm so sorry, but rather the general exceptions. And general exceptions, as we mentioned under chapter 4 of your Indian Penal Code. Right? So let's start with the sections and we'll try to understand that what exactly these sections are all about, and how is it important and why is it important, and whether it is actually applicable in the real world or not. That is something that we need to study. Okay, so with this we'll start with section number 76. And before all these sections, I would just tell you that you need not worry and you need not go, but you need to just understand from section 76, rather chapter 4, which talks about the general exceptions. And the first and the foremost says that act done by a person bound or by mistake of fact, believing himself bound by law. Okay. So I'll just give you an example. An act done by a person bound or by mistake of fact, believing himself bound by law. Now this particular exception clearly shows that there is a person who is bound by law to do something, and because of that mistake that he is bound by law, he does something, then he will not be punished. I'll give you an example for your better understanding. That there is a mob that is going there, that is present in a particular park or maybe an amusement area, and then suddenly there is a bunch of army people who are going there, and the army general got irritated of that group of people, of the bunch of people who are acting, who are enjoying there, and he suddenly asked his soldiers to open fire over those people. So that act, the act of the soldier, cannot be considered as an act which is unlawful in nature. Because why? Because according to the law, he has been bound to follow the orders of the general. So the general can be punished. The general can be punished, and obviously he will be punished because it is a unlawful act. But the soldiers who fired over the people, the mob, the innocent people, shall get protection by virtue of section 76 of Indian Penal Code, and they shall not be held liable for committing murder, but rather the general only will be held liable for committing the murder. So that is why we need to obviously understand that what exactly this general exception is all about. You see, by merely reading section 76, you got an idea that there has been instances where which a person who has been following orders of his superiors has committed something which according to him was not wrong, but obviously because he was following the orders of the superiors. And if he has done something in good faith, just abiding by the orders of the superiors, he has done nothing wrong, because he was bound by the law, or rather I would say bound by the orders of the superiors to do that act. And if he would have abstained in doing that particular act, then obviously he will be considered as an offender. But let's take another example and let's try to modify this fact only, that there are a certain group of soldiers who know that general is taking vengeance, or if I may say personal rivalry from the mob, and those soldiers, with the intention to kill, murders numerous people that were there in the mob. So it becomes obviously understandable that the soldiers who were actually knew that the orders that has been given by the superiors is something which is unlawful, so they are not bound by the law to do that. But still, if they do it, then they will be held responsible for committing murder along with the general. But those soldiers who were not having this knowledge, and they thought that these are actually, instead of innocent people, they are a terrorist, and they attacked those mob and they have killed it, they will not be punished. Rather, they will get protection under section 76. In the same way, if we talk about section 77, which talks of act of judge when acting judicially. So you might have seen that the judge has been given this authority that they can provide imprisonment, that the person can be held, can be taken to behind bars, and there is a provision of punishment of him being in the jail for a certain amount of time. But if we talk about the general principles, there is one principle which is known as wrongful confinement and wrongful restraint. So means if you are confining somebody within a small wall. So if I'll just take an example, if I'm sitting in a wall, if I'm sitting in a room right now, the area from which I'm being surrounded are the four walls. And if somebody locks me inside that house, then there is an offense that has been committed by that person, which is known as wrongful confinement. That without my approval, without my intention, he has restrained me from moving to any directions. And as of now, and I've been only be restrained to work in this particular area. Now, why is it considered to be an offense? Being that in India, you have the constitution, which talks about the fundamental freedom that has been allotted to each and every individual and the citizens of the India. So if somebody has restrained me from abiding by the fundamental rights, and by not allowing me to entertain my fundamental rights, get my fundamental rights, then obviously it is something which is considered unlawful, and they can be punished for that particular act. So that is why it becomes very important to understand these general exceptions. Now, if we were talking about the wrongful confinement, I just informed you that this is what wrongful confinement is. And in the same way, but if we talk about imprisonment is also a sort of wrongful and confinement, right? That there will be a person who will be put behind the bars, and he will not move in a certain directions, and it has been done by a judge. But we see in our society that once a person has done something wrong, and the judge is sentencing him for punishment, and the judge cannot be held liable. Why? Because judge is doing something within the brackets of the law. He is being authorized to give punishment to the candidate, to the criminals, and that is why any act done by the judge judicially cannot be considered to be an unlawful act. So even if they are asking somebody to be hanged till death, in normal circumstances it would have been considered murder. But a person who has sentenced a somebody to be hanged till death cannot be held liable because he's falling under the general exceptions. In the same way, 78 talks about act done pursuant to the judgment and or order of the court. Now suppose that there is a court order where which a person is supposed to be hanged till death. Then there is a person who is supposed to carry out that business on the day when the person has to be hanged, and the hangman pulls down the lever, and because of which the person who's been on ropes dies because of suffocation. Then that person should also be held liable for in general circumstances. If you have put a rope to your friend or maybe another person and you ask him to be hanged, and once he hangs and because of the suffocation he dies, you will be held responsible for committing murder. But in general, but when we talk about the general exception, it is clearly showing that the hangman is having protection under the general exception, that whatever the acts he is doing is what? It is not unlawful and rather lawful. And that is why his acts will not be considered to be punishable under the provisions of Indian Penal Code. I suppose you're getting the idea as to why it is so getting important to understand these acts, rather these principles, because once you're acquainted with these principles, again I'm telling you, it will be very easy for you to solve the questions. Take into consideration the principles of the general offenses, the definitions of the general offenses. Let's move forward and then let's go through this particular point 79, which talks about act done by a person justified or a mistake of fact, believing himself justified by law. So now there is one person who does an act. It is almost the same between 79 and 76, if you can see. But here it is an act which has been done voluntarily. It has not been done involuntarily, but by the orders of some person. And this act has been done voluntarily. But believing it that it is justified to do that particular act. For example, if somebody tries to help a person who's dying from pain, let's take the example of doctors. Yeah, you have heard of doctors. So doctor is doing something in order to save the person's life. But during the operation, the person dies. And often has been seen that people start accusing the doctors that because of their negligence, because of their not being committed to my patient, the patient has died. But I would like to tell you that it is not the scenario. The doctors try their level best to provide the medications and everything. There might be some exceptions, obviously, I believe. But in the general tendency, it is a general tendency that doctors are expected to work in such a manner that they try their level best to save the person's life. But let's take an example, and this would have been an offense, and they would have been allowed to take actions against the person. That if while saving also the person, if the person dies, then doctor can also be held responsible. Then, to be very frank, in the society, every doctor would have been hanged till death, because there have been numerous instances where a doctor is supposed to save the child, save any person, but because of things beyond the reach of the doctor also, the person has succumbed to injuries and has died. So 79 gives protection to those people. Just give you an example of doctor, and any a person who is working in the same manner as the doctors are. If they are doing anything which is which they believe to be justified, or by mistake of fact believing him to be justified by law, that is either they have the justification that have been under foundations by the law to do this particular act, like the example of a doctor, or if by any default from the society's act that this particular person is supposed to do a particular act, and he's doing that act under the impression that I am supposed to do that particular act, then also that person will not be considered to be held liable. Let's move on to section 80, which talks about accidents in doing a lawful act. So there are two things, accidents and lawful act. If you do accident to murder someone, can you be held liable? Answer is yes, because it is not a lawful act. So what happens is, that you must have seen in movies that there is a truck driver who is come in, there is a villain who is inside the truck who's driving at a speed of 70, 80, and he rushes into a car where the hero is there, and because of which the hero succumbs injury and he dies. So these type of incidents are actually not true when you talk about the implications and the applicability of the Indian Penal Code in the real world society, where which if the accident would have been done while doing a lawful act. For example, there is a bus driver who is carrying 20-25 passengers on a hilly station. After a certain period of time, he feels that there is something wrong in the bus, and he tries to stop the bus, but eventually the bus never stops, and he falls off the hill, because of which the passengers that were inside the bus succumbed to injuries, and out of them 10 or 12 died. So whether or not the driver of that bus can be held liable for that, for the killing, for the murdering, or if I'll say the death of those passengers, the answer will be no, because he has done everything in a lawful manner, and just because it is an accident, the driver cannot be held responsible. But again, there are various factors that one has to take into consideration when they are seeing whether this particular act or is actually an accident or it was intentional. Had been the scenario that the bus driver was in the was intoxicated, okay, and it was a voluntary intoxication. So if there is a voluntary intoxication, then at that point of time it is not considered to be a lawful act. Just give me 1 minute. This is section 85. This is an exception which I was just telling you about. Reasons for intoxications caused against his will. Okay. Act of a person incapable of judgment by reasons of intoxication caused against his will. Okay. So you cannot take a defense in the court that, sir, if I have murdered somebody, you cannot take a defense in the court that I have murdered someone because I drank too much. And was not in my senses to understand what I'm doing, then it cannot be considered as an exception, because it is a voluntary intoxication. Since you're voluntarily taking these things, voluntarily intoxicating yourself, then it cannot be considered as an exception, and you cannot take protection under the general exceptions. You will be held responsible for murdering the other person. So that is why it becomes important that the intoxication, and there is a latent term that one needs to remember, and that is voluntary non-fit injuria, and that particularly talks about that if there is a voluntary acceptance to injury, then you cannot take any defense. So what does it mean? It means that the person voluntarily took the intoxication, and then he obviously murdered someone. Because of that, he is going to now suffer. That is what he is going to be punished. So you cannot claim defense by stating that I was intoxicated and that's why I have committed this offense. Had I been in my senses, I would have not committed the murder, because it was not uh, against your will. So you had the will. You knew that if I will drink, then there are chances that I might commit something which which will be obviously not up to the mark, and that is why I should be very much very much vigilant that what I'm doing. But you didn't took those precautions, so it is clear that you have the careless approach, and that is why you need to be punished. And that is the reason voluntary intoxication is not considered as a defense whenever we talk about the general exceptions and trying to save the people who have been who have committed those offenses. So these general exceptions plays a very vital role in saving those people who are involved in whose names are there but they are innocent. We as an advocates do, and I'm just trying to explain these things to you so that you might get the interest of understanding the penal provisions. And that is, these exceptions helps the advocates to provide a story where which our clients are falling under this particular exceptions. For example, if there is was a I'll give you an example that if there was a quarrel between two people, and then at that point of time, the person has a X person is trying to beat the Y person, and Y person actually murdered X. So now there are instances where which we can claim to the court that the act that was done by my client Y falls under the general exceptions of right to private defense that has been mentioned under section 97, I suppose. Yes, 96. Things done in private defense and right of private defense of the body and the property. So if you can see that there are right to private defense that has been mentioned under section 97, which says that if X, who was in a fit of anger, tried to kill Y, and Y in his right to private defense murdered X, there will be no responsibility, and that Y will not be held responsible for murdering X. The reason being, he will get protection by virtue of chapter 4, which talks about the general exceptions. So general exceptions helps in figuring out those areas where which, if at all any act has been done, it will not constitute as an offense. Rather, the person who has committed it, that person can claim his defense if he matches any of the criteria that has been mentioned in the chapter 4 of the general exceptions, the chapter 4 which talks about general exceptions of the Indian Penal Code, which starts with section 76 and goes till section 106. So in this particular portion, we have around 40 sections, but we are not supposed to study the 40 sections in detail. I've just tried to explain you these 5 sections, and we'll quickly move forward and explain you 5 to 10 more, so that it is very much clear to you. I suppose you have now understood that what is accident? Act likely to cause harm, but done without criminal intent and to prevent other harm. Okay, now I'll give you a very classical example for this particular section for your better understanding. There is a road, and in that road there is a car which is driving at a speed of 90, and suddenly what he saw is that there is a two group of people who are standing there. There is one group which comprises of infant child and infant childs who are of on an average age of 10 to 15, and on the other side of the road there was a aged woman who was trying to pass the road, but eventually the driver lost control of the car, and he had only two options to choose, whether he has to drive his car through the infants, the people, the group of the 15 to 20 people who were of an average of 10 to 15, or he should drive his car over the old lady, the woman. So taking into this consideration, if the person moves over to the lady in order to save the lives of the maximum bunch of people, so he have done something which it cannot be considered as a wrong. Why? Because he was actually have no other option but either to kill the majority of the people or to kill the lesser number of people. He acted judicially, and he ran over the old lady. Yes, it was an accident, and obviously the lady, the representatives of that old lady will obviously feel that the person should be punished. But our law says that if an act is done in order to prevent another harm, okay, so that will not be considered as an offense, but rather a protection can be given under the general exceptions. Okay, and moving forward, then you have 82, which says that any act done by a child under 7 years of age. This is another maxim which is getting attracted, and that is known as doli incapax. Doli incapax means that if there is any act that has been done by a child under 7 years of age, then he cannot be held liable. So a 7 years of age, a child who is of 6 years of age, let's take the example. He is playing with a gun which is loaded and accidentally fires it, because of which the gun fires a bullet, and the bullet gets hurts his father or maybe mother or whatsoever XYZ person, and the person dies. Then at that point of time, the child will not be held responsible for murdering that person, because it was has a protection of under section 82, which talks about that any of the act which is done by uh, any child which is below the age of 7 cannot be held liable. Okay, same goes with section 83. Section 83 also talks about the child which is in between the age of 7 to 12, and then unsound mind. And if there is any act that has been done by a person who is unsound mind, who's of unsound mind, will not be held responsible. But again, there is a one exception here, that if during the commission of the act, by any proofs or any evidence that can be revealed, it can be revealed that while doing that particular act, he was not of unsound mind, but of rather of sound mind, then at that point of time, he can be held responsible. You must have seen in movies that the people get bail. Bail is something which is getting out of the jail, because they have they have gathered sufficient proofs. They have got a medical report which clearly indicates that the person is of an unsound mind. And you've seen that in the movies it's been shown that the villain is coming out making a mockery of the hero, okay, the actor, that I have been free from the jails and you cannot do anything because I've been shown that I am medically unfit to be inside the jail. So this is something that people take recourse to when there is any defense that has been claimed. But yes, what we need to understand is that if during the commission of the act, the person was capable and sound enough of understanding that what he is doing, then he will not be given the protection under this particular act. We have completed till section number 85, which has provided us for 1 2 3 4 5 6 7 8 9 10. So exactly 10 sections we have studied. We have tried to understand what are the important exceptions that is being attached. So if we are able to understand these sections, what it will assure is, what it will help us out in, that whenever there is any applicability and that there is any act that is falling within the brackets of the definitions of the different offenses that has been mentioned under the IPC, so what you can do is you can just you will be able to understand that okay, this act can be considered as uh, an offense if and only if it is not falling within the brackets of these general exceptions. If any of the general exception is present by virtue of studying that particular act which is there in your passage, if it is not falling under the general exceptions, the person can be held responsible. But um, if the offense is falling within the brackets, let's take an example that there was a murder that was done by a person who was of unsound mind, then yes, he can avail the protection under section 84, which talks about a person of unsound mind, and he will not be held liable. But in general context, if somebody murders somebody, he will be held liable, right? So that is why, after understanding the general principles, the questions will be very easy for you to solve. And with this, I would conclude today's lecture. We will continue with the lecture with the section 86, which we will be talking about the different other exceptions which a person will not be held liable. And then from tomorrow onward itself, we will start with the important offenses that one has to understand and study, because after understanding those bunch of offenses and understanding the general exceptions, you will be very much sound and prepared to go for practice of your Indian Penal Code problems. And once you get acquainted with it, you will be confident enough that this particular portion of yours, which is a part of legal reasoning, is well prepared and you will excel in your examination. With this, thank you so much guys for your patience hearing. I suppose that the things were clear to you. I would recommend you that you download this PDF that is available on net. You can download it from the government website. of where which you will be getting all the links of these bare acts. And after that, after downloading the bare acts, you are supposed to go through the sections itself. I'll just like to show you one section so that it becomes very easier for you to understand also. Yes, I suppose the screen is visible to you, right? Yes. So it starts with the general exception here. I just told you. And then it is says that an act done by a person bound by law, mistake of fact. Nothing is an offense which is done by a person who is, or by reason of fact of mistake of fact, and not by the reason of mistake of law. Not by the reasons of mistake of law means that the person has mistaken the law itself, that it is right to kill somebody. It is not right. Right? So we have to take that thing into mind, that it should not be the mistake of law, but rather the mistake of the fact that yes, I am bound to act on the basis of my orders of my supervisors. See, this is the illustration. A soldier fires on a mob by the orders of the superior officer in conformity with the commands of the law. A has committed no offense. But if there has been a conformity that the orders of the superiors are unlawful and still if he fires at the mob, then he will be held responsible. I suppose if you that is why you have to go through the sections. Go through section 76, 77, 78, 9, 10, 11 until section 85. You need to just read and go and read it. I have tried to explain in my best way possible. So I'm pretty much sure that you will be understanding the chapter, the sections as such. And from tomorrow onwards, we will start with section 80 from 86 onwards, where which we will be talking about offense requiring a particular intent or knowledge committed by a one person who is intoxicated. So if there is a person who had the will of doing something and just after getting intoxicated, even if it is involuntarily, then also the person can be held responsible. Yes, this is something that we'll be studying from tomorrow lectures onwards. We'll try to complete the general exceptions tomorrow, and then we'll start with the general offenses that is there. We'll start with the offenses against the body. We'll talk about murder, what is culpable homicide, what is wrongful restrainment. We'll talk about hurt, we'll talk about grievous hurt, and other offenses that are obviously important for a CLAT examination. And after completing that examination, after completed that portion, we will be moving forward to the code of criminal procedure. That will not be in a detail, but I would just, and obviously we will not be focusing our mind towards the procedure because that will not be asked to you in your question paper, but just some general principles that like what is the provisions of section 154 CRPC, which talks about the cognizance of an offense where which FIR has to be lodged. What are the grounds where which if the police is not acting efficiently, what are the methods that one has to go through, or what recourse he should take in order to make sure that his complaint is getting registered. So the provisions of section 156 is available there, and that is what you need to study in our lectures to come. With this, I end today's lecture. I wish you very best of luck. Please be consistent. Please practice as much as you can, and once you are able to complete that practice sessions, you will be able to get a good confidence that will help you in excelling in your question paper. Thank you so much, guys. May you have a good day. Bye bye.